Welcome to Navigating Your Florida Contested Divorce, the course where we turn I'm overwhelmed into okay, I have a plan. This is a roadmap for self represented parties, also known as pro se litigants. And you may want to write that down because that's the term the court uses for self represented individuals. And honestly, even if you have a lawyer, you'll want this information so you're not paying attorney fees for basic explanations and basic hand holding and emotional support that really they're not able and equipped to provide. All right. So, understanding your journey. Now, here's a quick reality check. Florida divorce, particularly when children are involved, is not just a fill out one form and you're done kind of situation. The process really matters because Florida has mandatory steps you cannot skip, like disclosures and parenting plans, and the stakes are very high. Missing a deadline can lead to default or dismiss motions or outcomes you didn't ask for. This course is your roadmap from filing to final judgment and beyond. This course here in particular is just the overview. We have lessons specifically tailored and designed for things like filing the petition and discovery and service and things of that nature that give you much more of a step by step process than this overview will. But we want you to have this foundation first. You can represent yourself effectively, but you have to be prepared and you have to respect the process and understand that you have to be paying attention. So before you file, jurisdiction and residency. So what jurisdiction is it's just the court's power to act over somebody. And the court does not have the power to act over an individual if the person hasn't lived in that area for a certain amount of time. In Florida, you have to be a resident for 6 months before you can file for divorce. At least one of you does. And that means you actually have to be there. So you'll need to show proof of residency, such as a valid driver's license, a Florida voter registration, an affidavit from other people, utility bills, things of that nature. Once you have all that and you've confirmed your residency and you have the proof of residency, you can move on to filing the petition. To file your Florida divorce petition, there are state required documents. Florida is very state specific. They have court required forms. Some states do not. Attorneys or pro se litigants do their own forms. Florida is not that state. In order to initiate the divorce and get it moving, there are several required documents. The first one is Form 12.901B1, and that's petition for dissolution of marriage with small children or dependent children. The civil cover sheet, the Form 12.902D, which is the UCCJEA affidavit. Now, the UCCJEA is a jurisdictional issue with children that most of the time attorneys do not even understand. It's very complex, but what it states basically is that Florida has jurisdiction of the children. The children are there and they have the power to make decisions as it comes to the children. So it's basically you're just telling the court where the children have lived and who they have lived with, so the court in Florida can make sure that they have the power to act. Next, you have the Notice of Social Security Number, which is Form 12.902J. Then you have Form 12.915, which is the designation of current mailing and email address. This lets the court know what your email address is, what your current mailing address is, so you can always be notified of filings from the other party and notices of hearing from the court. Form 12.900H is a notice of related cases. This lets the court know if there's any other cases going on that might affect you or your spouse or your children. Filing fees in Florida are about $400 to $420 depending on the county. That's a lot of money. You may be able to, depending on your circumstances, file a poverty affidavit or a pauper's affidavit, and you'll need to ask the clerk about that. And we also have one on our website as well. All right. So now that you have filled out the paperwork and you filled out all those forms, you go to the clerk, you pay the $420, you give them the documents, some of which have to be signed in front of a notary. And now is service of process. This is where you formally give the paperwork to the other party. It has to be done through the legally mandated way. You cannot hand it to them, you cannot mail it to them. It has to meet certain requirements. And if it does not, the entire case can get thrown out. So it's very important that this part is done correctly. Some other errors, small errors in paperwork can be fixed as the process goes along. This cannot. You need to make sure they get the paperwork correctly and in compliance with Florida law. So you can have the sheriff serve them, you can have a process server serve them. And Florida also allows service by mail. If the spouse agrees to that, they can also do a waiver of service. So this will be explained in more detail in the upcoming classes. Now, if you're the party getting served, it's important that you understand that you have 20 days to respond. You do not want to get a default judgment. Now, family court is a little bit more lax in terms of default judgments because children are involved and property is involved, but it's still important that you respond timely and the court knows that you're taking this seriously. So within 45 days after you're served, if you're the one getting served, or if you're serving the other party, both of you have to provide certain financial documents to the other. It's required. You cannot run from it. You cannot hide from it. What your attorney can do, or what you can do, is you can make arguments for why any financial obligations should be reduced based on certain factors and circumstances. But you cannot expect a reduction based on the fact that you just did not disclose it to the court. That will cause a lot of problems for you in the long run. So 45 days after the other party is served, you'll need to plan on giving them 3 years worth of your tax returns, about a year's worth of bank statements, 2 years worth of credit card statements, loan applications, recent pay stubs between the last 3 to 6 months, any retirement account statements, deeds to real property, and insurance declarations. You need to do your best to find this. It is time consuming, it is a hassle, but go ahead and prepare for that mentally so you're prepared and they do not file motions to have you sanctioned and you get in trouble because you have not provided this information. This helps the court determine things like child support, property division, attorney fees, and so on. Now, those are just the mandatory disclosures. Those are not filed with the court. You don't go up to the clerk of the court and file those documents, your bank statements, your tax returns with the clerk. That doesn't happen. You give it to the other party, and then you file a certificate of service with the court saying, hey, I've given this to the other party. If that's not enough, if you want more information, if there's more information to, address, such as information with children, other financial issues, things of that nature, you'll want to use other discovery tools. That's just the mandatory under Florida law. You also have other discovery tools at your disposal that our other classes go into, such as interrogatories, asking them a bunch of questions about things that have gone on during the marriage, requests for production, asking them for more documents and information, request for admission. And these are very important because if they don't admit or deny within the time frame, then the requests are deemed admitted. There's also depositions. We will not be getting too deep into depositions, but they are available for you if you want to use them. It require a court reporter and you there personally asking questions. They can get pretty expensive. We're going to focus on the interrogatories, the request for productions, and the request for admissions in the upcoming classes. All right. Divorce cases take time. They can drag on for a lot longer than most courts like and most people like. As a result of this, temporary expectations have got to be set out. So after you file and the other party is served, mandatory disclosures are made. At that point, steps can be taken to get some temporary relief, such as temporary child support, um, temporary use of the home, temporary alimony, temporary child time sharing. You can even get temporary attorney's fees if you're using an attorney. So these are things while the divorce is pending, so you're not languishing for a year and a half while this is in court. All right, Florida parenting plans. A parenting plan basically is just telling the court what your expectations are and your desires are with the children. Florida now presumes 50-50 equal time sharing between parents and children, and they believe that's in the child's best interest. In order to overcome this presumption, you have to show by preponderance of the evidence, which that's less than beyond a reasonable doubt, which is a criminal burden of proof. So this is preponderance of the evidence that equal time sharing is not in your best interest. And to do that, you would need to present evidence of the children's schedule, child rearing task, who has more knowledge of their doctor's appointments, any special needs, any evidence of domestic violence, um, neglect or abuse by the other party, things of that nature could help overcome the presumption that 50-50 equal parenting time is in the child's best interest. But you'll need to be ready for that if you do believe you have an argument that the child should not be spending half the time with the other parent. And we will talk more about that in other classes. Okay, so some of the best interest factors, which we will go over in the other class that addresses custody, is your capacity to facilitate the child's relationship with the other parent. That's big. If you're the parent that's alienating the child from the other parent and is talking negatively about the other parent, you'll be the parent that's less likely to get custody most of the time. The length of time the child's been in a stable environment, the child's home, school, and community record, um, ability to put the child's needs above the parent's desires. Things like that are all factors that the court considers for the child, and we'll go into that in our other lesson that specifically addresses child custody. So parental relocation is, a big deal, particularly when you're considering a family is divorcing and making other arrangements as where to live. So if Florida requires a petition to relocate with a new address, and the other parent has 20 days to file a written objection or lose the presumption. The relocating parent must prove relocation benefits the child. Mediation is required in Florida. That's another step. It typically comes after discovery. So you have the petition is filed, you fill out the paperwork, you pay your $400 fee, you get the other party served, y'all participate in mandatory disclosures, then specific discovery. And now you're at the point where you've gotten each other's information and you go to mediation. The only time mediation is not required is in case of domestic violence or certain other maybe special situations, but it is required because the court wants you to try to work it out for yourself. Child support is calculated on both parents' incomes and it assumes each parent will be contributing to the child's upbringing and care. We will go over the child support and the financial aspects of this in another lesson, but that is a factor to be considered. Permanent alimony no longer exists in Florida. So you can ask for alimony to kind of bridge the gap between the transition of divorce and single life, to rehabilitate yourself, meaning going back to school because you stayed at home with the children while you supported your spouse's career, things of that nature. So, but no, you're not going to be getting alimony for life in Florida anymore as of 2023. So just be prepared for that as well. So Florida, in terms of property distribution, they have an equitable distribution, meaning it's not equal, it's what's fair. So basically, what's acquired during the marriage will be distributed under an equitable basis. Your retirement account is part of that equitable distribution if you acquired it during the marriage. So be ready for that. So you don't always have to give up half of your retirement. Sometimes it can be used as a bargaining chip for other things, but be prepared that there is an entitlement there to an equitable distribution of that retirement, which is usually half, unless you can show the court that, hey, this is not fair. It's not equitable for the spouse to get half of the retirement, and here's why. So if you're not able to enter into an agreement in mediation, you have to start getting ready for trial. There'll be a case management conference, addresses scheduling issues, motions that are pending, a pretrial conference, witness list, and exhibit list. Be organized, get this all together. Do not play hide the ball with the court. Provide everything that you have, and then then make an argument for why things should be fair and why certain things should go in your favor. If you've made a mistake, own the mistake, admit to it, and let the court know that you're doing better. But in a family law case, in a criminal case, it's a lot different. In a family law case, you want to be as transparent as possible because the best interest of the child is what the court is considering, and they want to make sure the child is in the best environment as possible. And the best environment possible is a parent that takes responsibility for their actions and is open and honest and upfront. There will not be a jury trial, it will be a bench trial in a family law case in Florida. So you'll make opening statements. The petitioner goes first. They will get to present witnesses and evidence. The respondent can cross-examine the petitioner's witnesses and challenge their evidence. Then it's the respondent's turn. The respondent can present witnesses and evidence, and the petitioner can cross-examine the respondent's witnesses and challenge their evidence. There could be rebuttal witnesses if the court permits it, and then there's closing arguments. The petitioner will get the last word. They get to make a closing, and the respondent can make a closing, and the petitioner can get the last word and make another rebuttal closing, but the respondent cannot. So that's just something to be prepared for that, and that's why a lot of people like to file first. For the final judgment, you'll need to get an approved parenting plan. You fill out what you think is right and present it to the judge. The designation of parental responsibility, provisions for the children's health insurance, property division, the UCCJEA findings, which are extremely important, child support, and make sure that you have the parent education course, which is about $30 to $50 per person, done fairly early in the process, right around the time before you go to mediation. While you're doing discovery, go ahead and get that taken care of. After you get the judgment, you have, if the person's not following what the court said, you can always move to enforce that judgment, hold them in contempt if they're not listening to the court's order. You can move to modify it and change it if it's not working out, if it's not in the children's best interest. And you can appeal it within 30 days if you do not like the judge's decision and you believe they violated the law when they made the decision. Certain deadlines you don't want to miss is 20 days to respond to the petition, 45 days for mandatory disclosures, 120 days, they have to be served after you file and the case gets dismissed, 20 days to object to relocation, 30 days to file a notice of appeal, and 10 days for an exception to the magistrate's report, or else you waive those objections. Common mistakes to avoid: using outdated forms. Make sure you've got the updated form, and that includes if you're using our forms and our forms are not updated, let us know. We do everything to update and keep everything current, but once in a while we might miss a step, so please double and triple check that. For getting the UCCJEA affidavit, you need that. Just put where the children have lived. Filing in the wrong county, check and double check that you're filing in the correct county. Attempting to serve the spouse yourself, absolutely not. Get this deputy to go and serve them if they do not acknowledge service in front of a notary. The response phase, missing the deadline, filing an answer instead of a counter petition. If you're the one getting served, make sure you file a counterclaim for custody. Don't just answer, make sure you file your own counterclaim. And failing to preserve alimony claims. In the disclosure phase, the discovery phase, not reporting your income, that's a problem because they will find out and it will come back and it will bite you. So report the correct income, use the correct financial forms, keep to the deadlines. A lot of times the courts will extend some grace, but you don't want to count on that. Look like you're on top of your game, especially if you're trying to go for custody. For the trial phase, if you don't list witnesses or exhibits and you haven't turned it over, they could claim trial by ambush, and you do not want that in the middle of trial. Turn over the exhibits that you have. List your witnesses so you're not standing there in the middle of trial with the judge telling you no. Attempting to introduce hearsay. Hearsay is a very complicated concept, and we'll go into it in greater detail in the subsequent lessons. But Make sure if you bring in affidavits that you have them notarized, or any type of documentary evidence there's notarized, and that people, your witnesses, testify as to what they saw. Those are two big things. Get your evidence organized, get it labeled, have it ready. And finally, and this is the most important, do not show emotion in that courtroom. Do not give the other party that type of control. Keep a hold of yourself and your emotions at all times. This will be the most emotionally difficult situation of your life, and it will be the hardest thing that you have to do. But if you do it, it will pay off in dividends. We want to help this process be as informative for you. We want to make it as clear and transparent as possible. Please leave your comments. If we're wrong on anything in Florida, please let us know. If you need more clarification, please let us know. We cannot give legal advice, meaning we cannot give specific directions for your specific situation. But if you get on the comment section and say, hey, generally, this isn't clear. What you put here isn't clear in this class, we can go and correct that. We can put the correct forms. So let us know how we're doing and what we can do to make this process easier for you. Thank you.